If you're a naturalized United States citizen, what I'm about to share with you might feel unsettling at first, but I promise you, by the end of this video, you'll have clarity, peace of mind, and a complete understanding of what's really happening with denaturalization cases in 2026. According to recently leaked internal documents, we're looking at what could be a 16,000% increase in denaturalization referrals. Yes, you heard that correctly, 16,000%. But before you panic, there's crucial context you absolutely need to understand. Stay with me because the reality is far more nuanced than the headlines suggest, and I'm going to break it all down for you using my insider knowledge from working at the very agency that handles these cases. Welcome back to US Guide, the channel where we cut through the noise and give you accurate, reliable immigration information from someone who's actually worked inside the system. My name is Adrian, and I'm an immigration attorney who has spent years helping foreign nationals navigate the complexities of United States immigration law. But what makes my perspective unique on today's topic is that I used to work at the Department of Justice Office of Immigration Litigation, the exact office that handles denaturalization cases for the United States government. So when I tell you about denaturalization, I'm not speculating or theorizing. I'm speaking from direct first-hand experience of how these cases actually work from the government's perspective. Today, we're diving deep into the recently leaked documents about denaturalization quotas for 2026, and I'm going to share insights that you won't hear anywhere else. If you find this information valuable and you want to stay updated on the latest immigration developments that actually matter to your life, please hit that subscribe button and turn on notifications. And if this video helps ease your concerns or answers your questions, a like really helps us reach more people who need this information. All right, let's get into it. Setting the stage, what the documents reveal. So let's start with what we know from the leaked internal guidance. According to multiple sources, including the New York Times, internal USCIS guidance issued in December directs field offices to refer between 100 and 200 to naturalization cases per month to the Department of Justice during fiscal year 2026. Now, to understand why this number has created such alarm, we need to look at the historical context. Between 1990 and 2017, the United States averaged approximately 11 denaturalization cases per year. Just over 120 cases have been filed between 2017 and 2025. And this year alone, the DOJ brought 13 denaturalization cases and won 8. So we're talking about moving from an average of about 15 cases annually to potentially 200 to 2,400 referrals per year. That's where that 16,000% increase figure comes from. And understandably, it's causing significant concern among naturalized citizens across the country. Now, many of you have reached out to me through comments, emails, and messages asking whether you should be worried. You've told me about minor discrepancies on old paperwork, about mistakes you might have made years ago when filling out forms, about things you're not even sure you remember correctly from decades past. And I want to address all of those concerns directly. But to do that effectively, we need to understand several critical layers of protection that exist within the system. The high legal standard, your first layer of protection. Here's something absolutely fundamental that you need to understand about denaturalization. These cases don't happen in immigration court. They don't happen through an administrative process. Each case must be reviewed and decided by a federal court. And that distinction matters enormously. When the Department of Justice files a denaturalization case, they're filing in federal district court where they must meet an extraordinarily high legal standard. They have to prove beyond a reasonable doubt if it's a criminal case or by clear and convincing evidence in a civil case that you procured your citizenship illegally or through material misrepresentation. That word material is doing a lot of heavy lifting here. We're not talking about minor errors or small omissions. We're talking about facts that, if the government had known them, would have affected your eligibility for citizenship in the first place. Now, why does this matter so much? Federal judges are lifetime appointees. They're not political appointees who serve at the pleasure of any administration. They enjoy an extraordinary level of independence and neutrality. These judges take the Constitution constitutional protection of citizenship very seriously. The Supreme Court has repeatedly stated that citizenship and naturalization are too precious and fundamental to democracy for the government to take it away on their whim. Federal courts have consistently upheld this principle, requiring the government to meet that very high burden of proof. So, the first critical point I want you to understand is this. Even if USCIS refers your case to the Department of Justice, and even if the DOJ decides to file a lawsuit, you still have the protection of a federal judge who must independently agree that the government has met its burden. This isn't automatic. This isn't rubber stamped. Every single case requires judicial scrutiny, the Department of Justice bottleneck. Now let's talk about the second major factor that provides protection here. And this is something I know intimately from my time working there: the capacity and priorities of the Office of Immigration Litigation at the Department of Justice. This office is already incredibly busy. When I worked there, we were handling mandamus petitions, which are lawsuits filed when someone believes USCIS is taking too long with their case. We were defending against challenges to agency decisions in immigration courts. We were handling appeals from the Board of Immigration Appeals to federal circuit courts. The workload was substantial, and resources, while significant, were not unlimited. Now, here's what's crucial to understand about that leaked guidance. It talks about referrals to the Department of Justice, not actual lawsuits being filed. USCIS has been instructed to refer cases to the Department of Justice, but the Department of Justice doesn't have to actually proceed with these cases. This is a critical distinction that's getting lost in much of the reporting. Think about it this way. USCIS identifying potential cases and sending them over to DOJ is just the first step. Once those referrals arrive at the Office of Immigration Litigation, DOJ attorneys have to review them. They have to evaluate the strength of the evidence. They have to consider whether the case meets the legal standards that federal courts require. They have to assess whether this is a case they can actually win. Former Department of Homeland Security official Morgan Bailey told Newsweek that it would be virtually impossible for officials to process the volume of cases that the new guidance demands. Bailey explained that lowering internal thresholds wouldn't solve the problem, noting that the DOJ's burden and the standard required to bring these cases in federal court haven't changed. What this means in practical terms is that the Department of Justice is going to be selective. They're going to prioritize cases where they have strong evidence of significant fraud or serious criminal conduct that was concealed during the naturalization process. The Department of Justice has indicated that it intends to prioritize cases involving individuals allegedly connected to organized crime, gang activity, financial fraud, drug trafficking, or violent offenses. They're not going to waste their limited resources and their attorneys' time on weak cases that federal judges are likely to dismiss or rule against them on. Federal courts, the ultimate check on government power. Let me take you inside how federal courts actually approach these cases, because this is your most powerful protection. Federal judges understand that citizenship is not just another immigration benefit. It's not like a visa or a green card. Citizenship is fundamental to who you are as an American. It affects your right to vote, your ability to travel freely, your standing in this country, and even your family members' immigration status in some cases. Because of this, courts approach denaturalization cases with extreme caution. They scrutinize the government's evidence carefully. They hold the government to that high burden of proof strictly. And here's something else that's important. Federal courts are currently dealing with full dockets. They have criminal cases, they have complex civil litigation, they have constitutional challenges to various laws and policies. Adding hundreds or thousands of denaturalization cases to their dockets isn't something that happens quickly or easily. Each denaturalization case requires significant judicial resources. There are motions to dismiss, there's discovery where both sides exchange evidence, there are summary judgment motions, and if the case goes to trial, that's even more court time. These cases often take years to resolve. So even if USCIS refers cases and even if DOJ files lawsuits, the actual denaturalization process is lengthy, deliberate, and subject to rigorous judicial oversight at every stage. This is fundamentally different from how things work in immigration court, where judges are Department of Justice employees and work under different constraints. Federal district court judges answer to no one except the law and the Constitution, and they take that responsibility seriously, especially when it comes to something as fundamental as citizenship. Understanding the numbers in context. Now, let's talk about something that I think is really important for perspective, and it's something that hasn't gotten enough attention in the coverage of this story. More than 800,000 people were sworn in as new US citizens in 2024. That's 800,000 people every single year who go through the naturalization process. Even if we take the highest number from the leaked guidance, 200 referrals per month, that's 2,400 referrals per year. And remember, referrals are not the same as actual denaturalization cases being filed. And cases being filed are not the same as people actually being denaturalized. But even if we assume for a moment that all 2,400 referrals somehow became actual denaturalizations, which they won't, that would still represent only a tiny fraction of the total naturalized population. We currently have approximately 26 million naturalized citizens living in the United States. The vast majority went through rigorous vetting, background checks, English and civics testing, and interviews before being granted citizenship. So, when we're talking about 2,400 potential referrals out of a population of 26 million naturalized citizens, we're talking about less than 0.001%. Now, I'm not saying this to minimize anyone's legitimate concerns. If you're one of the people being investigated or potentially referred, that statistic doesn't make you feel any better, and I understand that. But what I am saying is that this is not an indiscriminate dragnet. The vast majority of naturalized citizens have absolutely nothing to worry about the quota system, why it's problematic. Having said all of that, I do want to address what I think is legitimately concerning about this guidance, and that's the quota system itself. Establishing a quota is new and fundamentally changes how these cases might be approached. Historically, denaturalization has been used as a very targeted tool for the most serious cases. The traditional example was Nazis, who had lied about their Nazi membership and came to the United States assuming different identities. We're talking about war criminals, people who committed serious fraud to enter the country, individuals with major undisclosed criminal convictions that would have made them ineligible for citizenship. When you impose a quota, you change the incentive structure. Instead of the focus being on finding and addressing the most serious cases of fraud, the focus shifts to meeting a number. And when agencies need to meet numbers, there's a natural tendency to look for easier cases, lower hanging fruit. That might mean pursuing cases involving people who made minor errors on their applications years or even decades ago, people who may have made honest mistakes rather than engaged in intentional fraud. Former USCIS official Sarah Pierce told the New York Times that requiring monthly quotas that are 10 times higher than the total annual number of denaturalizations in recent years turns a serious and rare tool into a blunt instrument and fuels unnecessary fear and uncertainty for millions of naturalized Americans. And I think that's exactly right. However, and this is crucial, even if USCIS identifies and refers these what we might call marginal or weaker cases, they still run into all the protections we've already discussed. The Department of Justice still has to decide whether they think they can win. Federal courts still have to agree. The legal standards haven't changed. So, while the quota system is concerning from a policy perspective and might cause unnecessary anxiety for naturalized citizens, it doesn't eliminate the substantial procedural and legal protections that exist. What types of cases are actually at risk? So, let's get practical. Many of you have asked me, what kinds of situations should I actually be concerned about? Let me be very clear about this because I think clarity here is more helpful than vague reassurances. The cases that are genuinely at risk of denaturalization typically involve one or more of these factors. Concealing serious criminal convictions that would have made you ineligible for citizenship. Lying about affiliations with terrorist organizations or groups that advocate for the overthrow of the US government. Using multiple identities to circumvent immigration laws, committing marriage fraud specifically to obtain immigration benefits, or providing false testimony under oath during your naturalization interview or citizenship ceremony. Notice what's not on that list: minor errors in dates or addresses on old paperwork, forgetting to list a traffic ticket from 20 years ago, small inconsistencies in employment history that don't affect your eligibility, honest mistakes made because you misunderstood a question, or failing to report something that wasn't material to your citizenship eligibility in the first place. The people who have reached out to me have almost universally been asking about things in that second category. Someone remembers they might have gotten a date wrong on an old application. Someone thinks they may have forgotten to mention a job they held for 3 months many years ago. Someone is worried because their address history might not be perfectly accurate. And to all of you, I want to say this clearly: those are not the kinds of cases that result in denaturalization, even under this new guidance. Could USCIS potentially identify and refer some of these cases to DOJ? Possibly, especially if they're under pressure to meet quotas. But will DOJ actually file lawsuits in these cases? Very unlikely. Will federal judges agree to denaturalize someone over minor paperwork errors? Extremely unlikely, almost to the point of being impossible, given how seriously courts take citizenship rights, constitutional safeguards, and legal precedent. There's another layer of protection here that's worth understanding, and that's the constitutional framework around citizenship itself. The Supreme Court has been very clear over many decades that citizenship is a fundamental right that cannot be taken lightly. There's a famous Supreme Court case from 1958 where the court said that citizenship is not something the government can take away as punishment or as a matter of convenience. The court has consistently held that denaturalization requires proving that citizenship was obtained illegally, not just that the person later did something the government disapproves of. This constitutional protection is important because it means that even if political priorities change, even if administrations want to be more aggressive about denaturalization, they're constrained by constitutional law and Supreme Court precedent. Federal judges who hear these cases are bound by that precedent. They can't simply ignore decades of constitutional law because an administration wants to pursue more denaturalization cases. Moreover, any attempt to lower the legal standards for denaturalization or to make the process easier for the government would almost certainly be challenged all the way to the Supreme Court. And given how protective the Supreme Court has historically been of citizenship rights, there's good reason to believe those protections would be upheld. The practical timeline. Reality. Let's talk about timeline because I think this is another factor that provides some reassurance. Even under this new guidance, even if USCIS dramatically increases referrals, denaturalization is not something that happens quickly. First, USCIS has to identify potential cases. That requires reviewing naturalization files, which means pulling old records, sometimes going back many years or even decades. Then they have to conduct an investigation to gather additional evidence. Then they prepare a referral package for the Department of Justice. Once DOJ receives the referral, their attorneys have to review the file, assess the evidence, research the legal issues, and make a decision about whether to proceed. If they decide to proceed, they have to prepare and file a complaint in federal court. Then, the person who's being sued gets served with the complaint and has time to respond. They can file a motion to dismiss, arguing that even if everything the government alleges is true, it doesn't meet the legal standard for denaturalization. If the case survives that motion, there's a discovery period where both sides exchange documents and take depositions. That can take months or even years. Then there are summary judgment motions, where each side argues that the undisputed facts entitle them to win without a trial. If the case goes to trial, that's more months of preparation, the trial itself, and then waiting for the judge's decision. And after that, there are appeals. The point is, this is a long, deliberate process with multiple decision points and multiple opportunities for cases to be dismissed or decided in favor of the citizen. It's not like immigration enforcement where someone can be detained and removed relatively quickly. Denaturalization requires going through the entire federal civil litigation process, and that simply takes time. What you should actually do so, with all of that context, what should you actually do if you're a naturalized citizen? Let me give you practical guidance here. First, for the vast majority of you watching this video, the answer is nothing different than what you're already doing. Live your life as a United States citizen. Exercise your rights. Don't let fear or anxiety about these headlines change how you live. The overwhelming likelihood is that none of this affects you. Second, if you know that there was something seriously wrong with your naturalization application, if you intentionally concealed serious criminal conduct or provided false information under oath, that's a different situation, and you should consult with an experienced immigration attorney to understand your specific circumstances and options. Third, if you receive any communication from USCIS or the Department of Justice regarding your naturalization, don't ignore it, but also don't panic. You have rights. You have the right to legal representation. You have the right to challenge the government's case in federal court. Immediately consult with an immigration attorney who has experience with denaturalization cases. Fourth, if you're in the process of applying for naturalization now or in the near future, be scrupulously honest and accurate on your application. Take your time filling out forms. If you're not sure how to answer a question, consult with an attorney rather than guessing. Keep copies of everything you submit. The best protection against denaturalization is a clean, honest, accurate naturalization application in the first place. And fifth, if you're feeling anxious or worried despite everything I've explained in this video, it might help to consult with an immigration attorney just for peace of mind. They can review your specific situation and give you personalized advice. Sometimes just having a professional tell you that you have nothing to worry about can ease a lot of anxiety. The bigger picture, understanding government priorities. I want to zoom out for a moment and talk about what this guidance tells us about government priorities more broadly. The Department of Justice has indicated that it intends to prioritize cases involving individuals allegedly connected to organized crime, gang activity, financial fraud, drug trafficking, or violent offenses. That gives us insight into what they're actually looking for. They're not trying to denaturalize millions of people. They're not trying to create widespread fear in immigrant communities. What they're trying to do, according to their stated priorities, is identify and remove citizenship from people who never should have become citizens in the first place because they concealed serious criminal conduct or terrorist affiliations. Now, you might disagree with the quota system. You might think this is bad policy. And as I mentioned earlier, there are legitimate concerns about quota-driven enforcement, but it's important to understand that the legal infrastructure exists to prevent this from becoming an indiscriminate campaign against naturalized citizens. The Department of Justice has limited resources. Federal courts are independent. The legal standards are high. All of those factors act as natural checks on how far this can actually go, why this information matters. Now, the reason I wanted to make this video now in January 2026 is because I know many of you are seeing headlines and feeling scared. You're wondering whether your citizenship is secure. You're questioning whether you should avoid traveling internationally. You're worrying about whether errors from years ago might come back to haunt you. And while I can't give you individual legal advice through a YouTube video, what I can do is give you the framework to understand what's actually happening, what the real risks are, and what protections exist. Knowledge is power, especially when it comes to something as important as your citizenship status. I also want to emphasize that this situation is evolving. The guidance was just issued in December 2025. We're now seeing how it's actually being implemented. There will likely be legal challenges. Immigration advocates are already raising concerns. Federal courts will ultimately decide how far this can go, so it's something we'll continue to monitor and update you about on this channel. Resources and next steps. If you want to learn more about denaturalization, I have several other videos on this channel where I go into more detail about how the process works, what the legal standards are, and what your rights are if you're facing a denaturalization case. I'll link to those videos in the description below and in the cards above. I also want to remind you that immigration law is complex and individual situations vary tremendously. While the information in this video is accurate and based on my professional experience, it's not a substitute for personalized legal advice. If you have specific concerns about your naturalization or citizenship status, please consult with a qualified immigration attorney who can review your individual circumstances. For those of you who are still in the process of navigating the immigration system, whether you're applying for naturalization or helping family members with their cases, accuracy and honesty are your best protection. Don't try to hide things. Don't misrepresent information. Don't make assumptions about what the government does or doesn't know. If you're unsure about anything, get professional guidance. And remember, the vast majority of naturalizations are completely legitimate. Most naturalized citizens went through the process honestly and correctly. Those people have nothing to fear from this guidance, regardless of the numbers being discussed. I hope this video has helped clarify what's really happening with denaturalization in 2026, and more importantly, has given you some peace of mind. The headlines can be scary, but when you understand the legal framework, the procedural protections, and the practical realities, the picture becomes much less frightening for the vast majority of naturalized citizens. If you found this video helpful, please give it a thumbs up so more people can find this information. Subscribe to US Guide if you haven't already, because we'll continue covering important immigration developments as they happen. And hit that notification bell so you don't miss future updates. If you have questions or if there are other immigration topics you'd like me to cover, leave them in the comments below. I read every comment and I use your questions to guide what videos I make next. Thank you so much for watching, for trusting me with your concerns, and for being part of this community. Stay informed, stay calm, and remember that knowledge is your best defense against fear and misinformation. I'll see you in the next video.